Let's get analysis. We're now joined via Teams by international law expert Prof. Hennie Strydom. Prof. Hennie, good afternoon, and thank you for your time at the SABC at this hour.
Yeah, good afternoon to you, to the viewers.
Prof, let's just look at South Africa, focusing on the apartheid regime that Israel has imposed on the Palestinian people. At the rulings, calling it a colonial system. And all three speakers really demanded that the court put an end to the occupation and have illegal settlements removed. So from your vantage point, how solid was South Africa's presentation?
Well, I have to state at the outset that the law on this is fairly clear and established in United Nations resolutions, in earlier advisory opinions by the court and so on. And the established law deals basically with the unlawfulness of the settlements and of the the duration of the occupation, which raises the question whether we are not talking about an occupation anymore, which should be temporary, but that we are talking possibly about an annexation. And that is one of the questions before the court at this point in time, apart from the issue about the policies of Israel that could be seen or classified as apartheid policies. And I think that's the other interesting point that has been placed before the court by South Africa, and it would be interesting to see how the court is going to deal with that. But as I've said, much of the law is already established, and that is what South Africa, and I think the other countries as well, of what I've seen, are concentrating on.
So, Prof. Hennie, on the back of that, instead of 11 countries having their oral arguments at the Peace Palace today, it's only going to be 10. Canada pulled out at the last minute. We just, in fact, heard from the court. What should we be reading into this at this point?
About the withdrawal?
Yes.
Yeah, I don't know what the reason for that is. What I can say is that there are 52 countries that have announced their willingness to and preparedness to submit. And that's an unusual large number. In the case of Ukraine versus Russia, we had about 30 countries. So this is a significant number. And it will give the court with a wide range of opinions on this issue.
Thank you, Prof.
So the withdrawal of Canada as just one state is not significant.
Okay, Prof, thank you for that. Because just for context sake, for the benefit of our viewers, how is this case different from South Africa's ICJ case against Israel? And really, as we look at the advisory opinion that's set to come forth, are there concerns about its efficacy, also just respect for the international rule of law? How would you unpack it from your vantage point?
Advisory opinions are different from cases where the state has to decide on an actual dispute between the parties. The whole role and objective of an advisory opinion is to provide clarity about the legal position where there is uncertainty about the legal position. And in this case, the advisory opinion or the request for it came from the General Assembly. And the reason for that is so that the General Assembly, as one of the main organs of the United Nations, knows exactly what is the legal position and how it should sort of react to that and adopt resolutions or policies in regard to the situation. And that is the importance. It brings clarity, not only to the United Nations, but also to other members of the United Nations. And this is the importance of it, so that the members of the UN will know where they stand with regard to what the legal position is. We had a similar situation in the case of the Southwest Africa Namibia cases, on the allegations about South Africa's illegal possession or administration of the area.
Well, Prof, just looking at whether we are any closer to a two-state solution on the back of what is transpiring, given the added political pressures, what's your opinion on that? And if we look at the ruling, what are we expecting? What precedents could this also be setting at this point for the world at large?
Well, as far as the precedents are concerned, I think the two issues that I'm interested in, I think many other people relate to the question about the status of the occupation. How should it be classified in terms of international law? Is it still an occupation or is it an annexation? And I think that is an interesting point. And the second one, if the case is going to announce on it, whether the policies of Israel can in fact be classified tantamount to apartheid policies. So the outcome, of course, we have to speculate on, but I think the court is quite aware of the sort of seriousness of finding a solution to that, and if it provides the kind of opinion that we're all expecting, then it has consequences for many states in terms of the obligation not to recognize the occupation of Israel, but secondly, more so for Israel. If the court finds, for instance, that's a duty on Israel to dismantle its settlements, which is one of the very contentious issues concerning the occupation.